Hi, this is attorney Mike Gravlin, and today we're going to talk about what to expect when you have a workers' compensation case in the state of Illinois. I've done this sort of work for over 20 years, and I'm going to share some tips and strategies with you. Welcome to Law Talk. Each year, there are over 40,000 claims made under the Illinois Workers' Compensation Act. Almost all the employers in the state are required to carry it unless they're a federal employer or with a few small exemptions that are beyond the scope of this conversation. But the vast majority of the population that is working in the state of Illinois is covered by the Act. There are three main benefits that you're seeking in a workers' compensation case, and those are medical, TTD, that's payment for the time that you're off, and permanency, which is the settlement at the end of the case. Okay, so now we get down to the nitty-gritty. You got hurt at work, what do? Well, the first thing you do is you report the incident. The second thing you do is you get treatment for the incident. And when you're getting treatment, you make sure that they know that it's a work-related injury. That will make everything flow much better later on. Somewhere along the way, you're going to have to fill out a Form 41 with your employer called a first report of incident, and you go, and it's just a form, and you say what happened, and that's basically that. We need to get this notion of being nice out of the way right away. This is your livelihood. This is your body that's been injured. You have rights under the Act that you should assert in that circumstance, designed to compensate you for just this scenario. It has nothing to do with being bad or being mean or not liking your employer. I assure you that all the actions they take are under the guidance of their legal counsel and their insurance company and the adjuster, and they have plenty of help to make every move on their end. It is only fair that you get representation so that you can make appropriate decisions. This is not something that you can do by yourself well. It's a very specific area of law, and in fact, it's not just any attorney. You need to get an attorney who's experienced in this area. They're all over the place. There are attorneys throughout the state of Illinois that do this, but most don't. You really have to check and make sure that this is something they do. This is not something you dabble in. It's very, very specific, and the statute is kind of esoteric sometimes. So you either know this or you don't. Check references, call, ask friends, all the usual things that you would do to figure out if somebody really knows what they're doing. But you're going to need some help in this, and you're going to need it as soon as possible because you're making decisions immediately in this case. It's an ongoing situation where you're trying to decide what information to provide, what I should be saying to my employer, what I should be saying to the doctor, should I go back to work? If they have me on restrictions, should I return to work when I know that it's likely that they're going to make me exceed my restrictions? Those are all the sorts of questions, and the answers are really differ based on the specific circumstances of the case, the arbitrator you're in front of, the circumstance you're in, and the only person who can really do that is someone with experience who knows what they're doing. I got three basic tips for you to help move things along and will really make a big difference in your workers' compensation case. The first one is to open some sort of a file. It could be paper or computer or both, and keep track of all your records and bills. And really, one of the most important things is to keep track. You might just want to get a calendar of the days that you've missed, because at some point in the case, there's going to be a discrepancy over whether or not they paid you for the time that you've missed. Now, they will always claim they did, and the only check on that is your record of what days you've missed versus what payments have been received during the course of the case. The next one is to make sure that you, of course, keep track of all your medical bills, because they usually, medical bills are really complicated, and especially if there's a lot of treatment, things can get missed even if they're paying them. Sometimes they're disputing them, and then you need them all anyway. But Your attorney will order all the medical bills, but there's always a chance that something gets missed. A lot of times it's the anesthesiology bill or something like that. You'll order from a hospital and you'll get most of their records, but somebody will show up later with an x-ray bill or something like that, and you're really the best source to get that to your attorney so that they can make sure it gets taken care of. And then the other thing you want to do is document any conversations you have with the employer. That's another big area of contention. Hey, we told the person that they could come back to work and they refused to, so we shouldn't have to pay them for the lost time. You have those sorts of disputes all the time, so you really want to keep track of the conversations you have. My preference is when we're getting into that scenario where if it's a return to work and when did they ask, I prefer, although it may not be natural in that circumstance, but I prefer that be on an email, just so that everybody knows when what was said to who. But if not, if you're having phone conversations, you can make a note about it and provide all that to your attorney so that they can properly argue for you on your behalf. Otherwise, you're just at the mercy of whatever the employer says happened. They have payroll and human resources and all that sort of thing. They're not perfect, but they do have a record. And if they make a mistake, the only way you can really rebut that mistake is if you have your own records. There are a few other considerations as well that any attorney will help you get through, but one of the things you should consider is, depending on the severity of the injuries, of course, you're always subject to being on camera for this one. They send people out to take video all the time in workers' compensation cases. I've been to many hearings where they bring video. They follow you to the grocery store. They take video when you go to an IME. Haven't discussed IMEs yet, but they will drive around and see what you're doing and see if you're exceeding your restrictions or doing something you shouldn't do. So you should always bear in mind that you might be watched during the pendency of a workers' compensation case. It's very common. It happens all the time. Now that I mentioned it, we should talk about IMEs. That the employer has the right to have you examined by their doctor for what they call an independent medical evaluation. And it's very important when that happens that you go to the independent medical evaluation, because under the Act they have the right to do it. And if you don't do it, then they can use that as an excuse to not pay you benefits and to mess up your case. So it's very important that you attend any independent medical evaluations that come up along the way. You do, however, have the choice of your own doctors, and that gets a little complicated. You get to choose your own doctors, but you only get two choices. So after that, you're kind of stuck with it. However, that's not as bad as it sounds. You get two choices of doctor, but it also includes the chain of referral. So if you go to your primary care physician, who refers you to, say, an orthopedic surgeon, who refers you for an MRI, who refers you to a pain specialist, all of that's in the same chain of referral. That's one doctor. And there are other rules involved in that. If the employer, the company clinic for the employer, it does not count as a doctor. But you only have two choices of doctor in a workers' compensation case, so you need to make those choices wisely. Okay, I'm going to address a couple more of the common questions that I get at the beginning of a representation, just to help you out. One of the first things that everyone's worried about is, am I going to get fired for filing a workers' compensation case? And the answer is overwhelmingly usually not. That creates exposure for a wrongful discharge case for the employer, and to be honest with you, a lot of times people are upset, but they usually get over it. Not always. It depends on the circumstances and the employer, but usually it all works out. The next question I get is, how long is it going to take? That depends entirely on the injury. If you need a shoulder surgery and you're a year to rehab, well, it's going to take at least that long and then some. If you have a back strain and do a month of physical therapy and feel better and go back to work, well, then it won't take very long. It really, that is driven mostly by the medical and also the level of dispute involved in the case. If everyone sort of agrees on the facts, then it's faster. If there are real disputes as to the level of injury or the cause of the accident or prior medical things like that, it can take a lot longer. And of course, the next one is how much is the case worth, and that takes time to figure out. You need to figure out what happened with you medically first. While you're off, you should be getting TTD, which is 2/3 of your average weekly wage. Your average weekly wage is defined as how much money you made in the 52 weeks preceding the date of accident. So, that's part of the benefits right there, and the medical is part of the benefits. But what they're asking is, what's the permanency? What's the final settlement? And I can tell you what the prime drivers are. The prime drivers are how much money do you make, what is your average weekly wage, and the severity of the injury. That's all I can say when I don't obviously have any facts in front of me. But any circumstance, any specific case can be evaluated, but you need the information first. That's all. So it can be done, but only at the appropriate time. So this is kind of a brief overview of this. I once did a continuing legal education seminar, and that was a couple hours long, but that was to attorneys, and this is really designed for clients, not for claimants and people who have actually been injured at work, to give them some assistance. I think this is going to be the first in a series. I'm going to do some more workers' comp. So if you have any questions that you would like answered, go ahead and feel free to put them in the comments below. Or you can also contact my office if you like. I'll put contact information down in the description. And if you found this helpful at all, I would really appreciate it if you hit like and subscribed and shared with friends.